Good evening, everybody. This is Jonathan Ginsburg. Hope you all are doing well. And we are live again. It is Wednesday, January 22nd, 2025. If you're watching this on replay, welcome. Thank you very much for tuning in. And what I'm going to do today, I'm going to start, normally I start by going through some of the questions that we get. We're going to definitely do that. But I want to do something a little bit different here, and that is to just kind of give you some thoughts about something that's I've noticed has been really important in the hearings I've done recently. And let me just show you what I'm talking about. Basically, this is for anybody over age 50 who is using the grid rules to try to win their disability case. And the grid rules, as you probably know, or may not know, but they are a set of rules that changes the definition of disability for anybody over the age of 50. And at 55, they become even easier to meet, and at 60, even easier. So basically, before or under age 50, you have to prove to Social Security that there is no job that you can do at all. But when you hit age 50, assuming you have a physical impairment, realize the grid rules only apply when you have physical or what they call exertional impairments. It does not apply to mental health or anything like that. If you've got physical impairments, you could be found disabled between age 50 and age 55, 54 and 864 days. 364 days rather. You can be found disabled even if you could do what is called sedentary work or sit-down work. And at age 55 plus, you can be found disabled even if you could do light work. Light work is defined as standing and walking 6 hours out of an 8-hour day, lifting 10 pounds frequently, 20 pounds on occasion. And sedentary work is basically standing and walking 2 hours a day, lifting 5 pounds frequently, 10 pounds on occasion. And let me just show you the grid rules. I've got a website called gridrules.net, and I want you to see this. And I'm going to explain to you why this is really important. So again, sedentary work, standing and walking 2 hours, sitting 6 hours in a day, lifting 10 pounds occasionally, 5 pounds frequently. What the issue has been at times is I will be making a grid rule argument, and my client will not testify in a way that is consistent with what the grid rules require. And that's what I want you to really think about. So if your attorney is making a grid rule argument and you're between age 50 and 55, the argument he or she will have to make is that you are limited to sedentary work or less. And as you see here, if you have a limited education, less than a high school education, and you have unskilled work or semi-skilled work that does not transfer, you are disabled. If you're a high school grad or more, let's go back over here, high school grad or more at 201.14, but no direct entry into skilled work, you are also disabled. And the way you get rid of skilled work or transferable skills is arguing you've got some non-exertional problem, focus, concentration, things like that. My point being is if you're arguing that you meet the grid at sedentary and your lawyer says, how much can you lift? You don't want to say 15 or 20 pounds. Now you want to tell the truth, obviously, but if you haven't thought about it before, you really want to give that some thought. How long can you stand? If you say 3 or 4 hours, then you're taking yourself out of the grid rule territory, because remember, at the sedentary grid, you have to be able to stand for up to 2 hours in a day, sit for 6 hours in a day. So if you said, I can sit for 6 hours, I can stand for 3 or 4 hours, then your testimony is not consistent with the grid rules. Same way at light, and this is for people over 55, which again is easier to meet because light work is defined as standing and walking 6 hours a day. That's a lot, lifting 20 pounds occasionally. And if you're in that situation, and you at 202.06, which I use a lot, you're a high school grad or more, but no direct entry to skilled work. And again, medication side effects, depression, anxiety, PTSD helps eliminate transferability of skills. If your attorney says, how long can you stand and walk? And you say, I could do it for 8 hours a day. I have no limit on that at all. Not consistent with the grid rule. How much can lift? Oh, 15, 20 pounds easy. Not consistent with the grid rule. So you want to make sure that your testimony is very consistent. And let me show you this is just some examples, and these are the last pages of some briefs I filed. In my cases, I always follow a brief, but here's what I would do is, I'm arguing this one here is a sedentary grid, that we're arguing that because of the claimant's chronic neck and back pain, poor balance, need for walker and cane, emphysema, her residual functional capacity would be a reduced range of sedentary, and that as such, grid 201.14 apply. All right, so I've laid that out in my brief. Now my client needs to basically say, again, assuming it's the truth, that she is limited to a reduced range of sedentary, which would mean standing and walking less than 2 hours, or lifting 5 pounds, not 10 pounds, less than 10 pounds. Here's another one. Let me scroll down to this. This is one I did the hearing I had today, and basically my client had a high school education. Again, it's another 201.06, but basically congestive heart failure, back pain, that sort of thing, and sedentary work. And so, he needed to testify, and he did, that he was limited to less than 2 hours of standing and walking in the course of a day. And that he could not, and although when we asked about lifting, I think he was a little less sure about it. I think he said 10 to 15 pounds. Well, that's not consistent with what the grid rule requires. So again, you just want to make sure that if your attorney is arguing in the grids, that you look really closely at what the grids require. And again, if you're over 55, standing and walking 6 hours a day, and if you're under between 50 and 55, 2 hours a day of standing and walking, your testimony needs to be consistent with the grids. And so when you are doing your prep work with your attorney, make sure that if you're arguing grids, that your testimony is very consistent with that, and you understand what the requirements are. And for goodness sakes, don't think about your capacity to stand and walk for the first time at the hearing. It needs to be thought of long before the hearing, because otherwise, you're bound to get nervous. And, and again, my case today, a very, very honest, honorable gentleman, and he even said during the hearing, that I sort of saw myself as one of these people, I could do anything, and it's been really hard for me to acknowledge that I can't, but I keep trying, and I think I can do anything. And, again, we finally kind of got him to acknowledge that he was having trouble doing that. But the point is that in his mind, he's still that 25-year-old, full of vim and vigor, who can do anything. But now he's 53, or actually 55 now, but 53 at onset, when he really couldn't. And so I had to really kind of, work with him to kind of get past this thought that he is he's got more capacity than he did. So that is just some thoughts about the grid rules. Again, if your attorney is going to use that, if you're going to use that, whether it's at the initial recon or at the hearing stage, understand what your testimony, what you're writing on the forms, what that needs to say to be consistent with the grid rules. Because, I will tell you, some judges will say, well, if you said you can do, 4 hours of standing and walking when you're trying to argue a sedentary grid, I'm going to take that as being what you can do, even if the doctor says something differently, because I'm going to trust that you know your body better than anybody else. So just want to think about that. Just be real careful about that. Okay, let us go to some of the questions here. We have Mrs. Bell, and basically she has a new DDS, Disability Determination Services, and these are the people, we call them the state agency. These are the people that Social Security contracts with, part of the state where you live, to do adjudication or claims management on behalf of Social Security. And, the DDS caseworker, claims specialist, adjudicator, it's all the same thing. Their job is to help Social Security or make a decision with the help of medical experts about what your capacity might be, whether you meet a listing, whether you meet a grid rule. So what Mrs. Bell is saying is that my new DDS worker in Texas, and I will tell you, Texas and Florida right now are the worst in terms of delays. Georgia's not too far behind, but Texas is really bad. She has a new DDS worker again, what that means is the previous one either got reassigned, quit, was fired, who knows? But, we have these cases sitting there, for months and months, but she's got a new one. Let me know my cases with the medical examiner reviewer. So basically the DDS worker is going to the in-house medical doctor, medical consultant at Social Security, and having that person review the records. Mrs. Bell said, I thought my DDS worker handled that by viewing the records. The DDS worker does, but they're not doctors. And so they rely on medical consultants to do review of the medical record and to offer recommendations about what your functional capacity might be. So that's what's going on now. That's good news in that something is happening. What will happen now is the state agency medical consultant will get back to the adjudicator and say, well, this person, Mrs. Bell, does not meet a listing, but we think her functional capacity may be light or maybe sedentary or maybe medium, whatever it may be. And then the adjudicator has got to put it all together, make a decision whether you meet a grid rule, whether your functional capacity is so reduced you wouldn't be reliable. Obviously, most of the time, the DDS caseworker, the adjudicator, and the medical consultant do not find that you are disabled. Doesn't mean you're going to lose. It just means they have found there's not those magic words in the medical record which says you've reached that threshold. You get in front of a judge, the judge has a lot more leeway there. But that's what's going on. She also said, and she's pursuing long-term disability, I had recommended a gentleman, a friend of mine named Eric Berger, to help with the long-term disability claim, and she's having to fight that as well. And so what I'm sure Erica's going to do is the administrative appeal, which is the first step, and after that, federal court. So it's a long road. And then she says, although she's filing for physical disabilities, they had me undergo mental status exam, and basically, it was pretty simple. You had to remember 3 words. And the reason they do that is sometimes in the medical record, there may be a reference to depression or anxiety, or maybe that's something you indicated in some of the forms that you're dealing with stress, anxiety. And generally speaking, medical consultative evaluations will help you. The reason for that is that the doctors, the psychologists that Social Security uses for consultative evaluations for mental health are practicing psychologists. And these are people that are, they're used to finding or identifying underlying medical conditions, and they're not working for insurance companies. Whereas the physical consultatives many times are industrial clinic doctors. Their job is to find a reason to turn you down. So it's rare that a physical consultative evaluation is really going to help you. It can, but it's rare. Whereas the mental health ones usually provide some level of limitation that can be used to eliminate certain categories of jobs. Now, if you remember, I had a consultative doctor, John Foster, on maybe a couple months ago, and he talked about, the way he looked at it. He does consultative evaluations. He's done them for some of my cases. And he's not an insurance company doctor, he's not an industrial clinic doctor, but he does them the way, he thinks it's done right. And he does it in a very organized manner. And if you haven't seen that, I'll be putting some clips of that out there on the YouTube channel. But if you get a chance to look at that, he does it that way. There's a lot of these consultative evaluations that are just really kind of BS. I mean, they're just, the person sees the doctor for about 15 or 20 minutes. The doctor never does any tests, doesn't touch them at all. And then they conclude they could do medium work. And again, this is right out of the insurance company playbook. So that is what you see sometimes. But it is not that unusual, Mrs. Bell, to get a consultative evaluation that is, seems to be kind of really, really minimal. And again, the physical consultatives usually aren't very helpful. The mental health ones can. And she basically said, spell the word world. That's very common backwards, a number sequence. And then, she'll give you 3 words and say, repeat those words. And, again, what they're doing is they're testing your short-term memory, your long-term memory. They're testing your ability to process things. And all these are well-known tests that mental health professionals use. And if you really couldn't remember some of these things, then there'll probably be some sort of limitation on, your ability for processing. And they may limit you, the report may limit you to entry-level unskilled job, which again is jobs, which is very helpful. So it may not eliminate all jobs, but it may eliminate semi-skilled and skilled jobs. And remember, at the grid rules, if you're in a grid rule category, you're over 50, the way we get rid of transferable skills is, depression, anxiety, focus, and concentration like this. So let's say in your case, I don't know how old you are, but let's say that the psych consultative evaluation comes back and says that you would be limited to, 1 or 2 step tasks, simple tasks, no complex tasks, no change in environment, no decision making. Well, that's going to eliminate any transferable skills. You may have had a fairly high level job, but now you don't have that anymore. So that would help you meet the grid rules. So it all kind of fits together. That's the way they do it. Okay. Ms. Crystal, who has been here before, I'm glad to see you back. How long does it take to hear back from your hearing? Will it show in the portal? Had the hearing this month in January of 25. It normally takes about 3 to 5 weeks. Now, I will tell you that it has been stretched out a lot longer. I've got hearings that I did in November I've not gotten a decision on. I think I looked in January, I got like 3 decisions so far, 3 or 4 decisions. So it's really slow. I think that the holidays really threw everybody behind, maybe the weather. And what's going on now is that the decision, the judge kind of makes his or her notes, sends it to a decision writer in some location. We don't know where that is. It's typically up in like Maryland or something like that. Just want to make sure my microphone is the way as it should be, which it is. And, the decision will be drafted up. It goes back to the judge. The judge will then review it. If there's any changes, it goes back to the writer, then it's released. So I typically tell people 3 to 5 weeks. Now I'm telling them 4 to 6 or 8 weeks. And really there's not much we can do about the delay. Theoretically, if it gets beyond 2 or 3 months, what I do is I contact the judge's office, and you got to be really careful because you don't want to, get the judge upset that you're pressuring, because I know that these judges want to get these decisions out as much as possible. But of course, I'm an advocate for my client. I want these decisions out sooner rather than later. So, if it's been 2 or 3 months, I'll reach out to the judge, what's going on. Maybe there was, every once in a while there was something that the judge had been waiting for, and our wires got crossed. And then if there's nothing going on, if it gets beyond 4 or 5 months, then what I've done in the past is I'll go to the hearing office manager, or I'll go to the regional chief judge and just say, no disrespect to the judge, but, my client is suffering, and, we need to find out what's going on. Again, the risk is that you get the judge upset with you. And again, most judges realize you're just doing your job, but, that's a risk. So I'm reluctant to put a lot of pressure on judges when I'm that close to the finish line, because I don't want the judge to sort of say, well, we're just going to go ahead and deny it because it takes too much time to write a favorable. And believe it or not, it takes more time to write a favorable decision than an unfavorable decision. And I got this from talking to a couple of different decision writers over the years. So again, sometimes it was taking longer. That's not a bad thing. And then as far as will it show in the portal, it will show a decision was made. Don't know if it says whether it's favorable or unfavorable. Now, what I do is there is a little program I use that basically goes into my electronic records express account. And what that means is that as an attorney, I have an account called the electronic records, or ERE account, where I have access to my client's disability files. And so this program, which is called Chronicle, it has my login information. It goes in every day and it looks to see have any decisions been issued. And if it is, it shows on the like a little status report. So I can see literally every day what's going on with all my cases when the things have been changed. But in particular, what I'm looking for is a decision that's been issued. And I don't see anything there for a while. Sometimes I'll go in manually and look in the ERE status section. That will tell me as well. But I've yet to find a situation where what Chronicle told me was different than what was going on really, in the actual account. I did have a situation where the Chronicle pulled the decision, and they pulled the wrong decision. I don't know, they from somebody else. That was the first time that's happened, but I'm gonna consider that a one-off unless it happens again. But for my clients, what I tell them is after the hearing, I will check literally every day, and as soon as I see something, I'll pull it and I will let you know immediately. But I do think it does show a decision was made on your portal, but I don't think it tells you that decision says. You have to actually look at the decision. Now, I've had people also tell me they've called Social Security and they'll be told, yes, the decision's been made. We can't tell you. I'm not sure why, but that's what they did. Okay. MJ also had his or her hearing this month. So again, I'm sure the same question: how long does it take? Anywhere from, let's say, 3 weeks to 8 weeks. Let's just say that. Rodney is here. Rodney's one of my regulars, a former client of my firm. One of the other attorneys in my office did his case with a really tough judge, by the way. She did a really good job, and she got a favorable decision of Rodney's case. And we have been kept in touch ever since, which I'm happy to see. Okay, and the grid rules, I've got that down here on the crawl, just so that, again, if you're over 50, bookmark that, take a look at that. It gives you, I've got some examples of how it all works and some case studies and things like that. I'm going to change the banner now to the case evaluation banner, because that way you know how to reach me if you want a case evaluation. Christina is in California. I think we asked last week, and I think you said that at that point you were not very close to the fires. I hope that's still the case. So Christina, you're a regular. I'm glad to see you here. I hope you are safe. You and your family are safe, and that you're not near the fires. So we've got No Sky here saying his weekly, usually here every week, weekly welcome and hello to Christina. And Garrett Coleman, thank you very much. I appreciate that. I really try to share what I know, because I know this can be really, really confusing. And, I just think that it's important for me to let you know how the system works. And believe me, in fact, I got an email from a gentleman today about 2 hours ago. He's like, he contacted me, and I wrote him back and I said, look, you've already filed your case. I think you have a winning case. He was at like 57 with clearly a grid rule case. I said, you're going to win, I think. You don't need to hire me at this point. Just go ahead and just sit on it. Let's see what happens. If you get turned down, call me. If you don't, you won, that's great. He emailed me, he said, I won, I got a favorable decision. Thank you very much. I'm like, great. And I said, if you wouldn't mind, fill out a review, do a review, which I've got that on the different crawl here. Let me see if I can pull that one up. So yeah, so if you've got value out of this, you've gotten a favorable decision, yeah, give me a review. That would be really, really helpful. That's what I asked him to do. And believe it or not, I love it when people win on their own. There's plenty of work out there. I've got plenty of cases, and there's a lot of disability work out there. And, if you can win on your own, great. I mean, again, it's not easy, but there's some situations where I'll tell somebody, and I think most attorneys who do this feel the same way. If you don't need to hire an attorney, then don't do it on your own. I mean, I've had people contact me with, terminal cancer. I'm like, look, file the application. You don't need me. Just here's what you need to say. Again, good karma. Good karma goes out, it comes back. So that's my take on it. Okay, but Garrett, thank you for the kind words. And No Sky says, put your most pressing question. We do some work together. That's so. No Sky is not a stranger to me. Christina Villarreal, we have one more fire. I saw that right before I went on, that there is a new fire out there. I think I read where there's going to be some rain coming, which would be really, really nice. I have a cousin who lives in Culver City, which is, I believe it is southeast of the fires. But she's all, I check in with her, and she's like, so far so good, but she smells the smoke and sees the air is smoky. So, you got to be really careful, because those fires can move really quickly, and you can go from being in pretty good shape to being in real trouble really quickly. And it's, don't mess with Mother Nature. Okay. Lily asks, is there a new rule where DDS can approve some claims without the medical doctor review due to the million-plus backlog? I'm not aware of any new rules. I know that Social Security is always tweaking the rules, but my understanding is that the adjudicator, when they issue an approval at initial or recon, there is a certain protocol they've got to go through. They are not medical doctors. Now, what would happen if they see a terminal cancer case, the medical record is clear, that there's obviously a significant problem. In that situation, the adjudicator might have the leeway not to send it for medical review. So it's certainly possible. I suspect that there are, and again, I'm going to try to get an adjudicator on here at some point. And if any of you are adjudicators that want to come on, please let me know. But I will try to get somebody on. And I think that there is a very specific protocol they have to go through. Because what happens is if they approve a case and they've not gone through the appropriate, procedure, then the person that reviews that adjudicator could come back and undo it. So I think that, you want to see them follow a procedure. But I'm not aware of any new rule. Could be, but I'm not aware of anything. Hey, Wolf, you're very welcome. Thank you for your videos. Thank you. Hearing is scheduled for tomorrow, but I got a phone call from the lawyer and the judge to adjust the onset date. But after 3 years and 2 months, I jumped at the opportunity. What Kay Wolf is talking about is something called amending the onset date. And I know I talked about this last week because I pulled a clip out, and I'm going to have that as a standalone video. You'll start to see some of these clips from these live streams as videos on the YouTube channel because, again, the questions I'm getting are really, really good. But I did one, but I'll go over it again, and that is when you file for disability, you allege the date you became disabled. That is called your onset date or alleged onset date. That is a date where you say, September 17th of 2023, I became disabled. Now, down the road, a judge looking at your case may say, well, there were no, let's say it's based on back issues. There was no MRI until February of 2024. And the MRI of 24 showed herniated disc. Some judges feel like if there's no objective test for a back pain case, they're not going to assume that you had back problems going back before. More often it's that there's just nothing. I had a case not too long ago where the judge believed my client. My client was very credible. He was very believable. The problem was he was getting his treatment from the VA. He had moved from one state to the other. And when he got to the new state, he couldn't get a VA appointment. This was during COVID. It took literally 2 years to get an appointment. Well, the problem was he had had a couple of years where he didn't work, so his insurance credits ran out at the end of 2020, if I remember correctly, and the medical picked up in 2022. The judge believed him. There's no question the judge believed him. He denied the case. Why? Because there was no medical that was consistent with the onset date. So what may have happened to Kay Wolf is either A, the judge looked at it and said, there's evidence of impairment, but as of this date, 2 months, 2 years, whatever it may be, after your alleged onset date, I'm comfortable approving you as of this new date. There are judges out there, I will tell you, who seem to make a habit of just changing onset date because they're trying to cut back on past due benefits awarded. I've had situations where a judge will say, Mr. Ginsburg, would you consider changing the onset date to, November 17th of 2024? Well, that means my clients, because there's a 5-month waiting period, there's no past due benefits. There's also no attorney's fees, but I will tell you that doesn't play a factor in it because, again, I've got to do what's best for my client. I will tell my client, if you want to take that, then take it because you get future benefits and there's no past due. But there have been times where, I've talked about with my client that I know the judge may try to pull this, and I'll say, here's what I'm thinking. I don't think we ought to do it. I think the evidence is strong enough where we can win. And, I would say 3/4 of the time the judge will back down if I say no. Sometimes the judge will go ahead and issue a partially favorable decision, in which case we may choose to appeal it. I've got a couple right now that I'm on appeal. But yeah, I'm not going to just roll over if a judge says I want to change the onset date for no good reason. If there is a legitimate reason, then again, my obligation to my client is to say, I think that you ought to take this, even though it'll eliminate past due benefits. And that's just the way it is. Write me a nice review, but you're not going to get past due benefits. I'm not going to get paid, and that's just the way it goes. So that's the sort of the skinny on changed onset dates. The big picture is, I would tell you that when you do your pre-hearing call with your lawyer, talk to him or her about, is this a situation where, the judge might try to change the onset date? If so, what do you think about it? Now, I will tell you that one of the things I'm seeing many times is, let's say that you allege an onset date when you were age 54 or you were age 49, and during the course of the case being processed, you turned 50 or you turned 55, which is when the grid rules apply. That is what I see when judges are changing the onset date. One of the most common reasons is the person changed age categories. They went from 54 to 55. So the judge will say, I'll approve you as of your 55th birthday because I think the evidence shows you cannot do, you're limited to light work or less. Or that, you went from 49 to 50 and I can see that you're limited to sedentary work, which means you grid out. So that could be something going on as well. So you got to look at your date of birth, your onset date, how old you were, and all these facts should be known to your lawyer. And when you talk about it, this is something that your lawyer can advise you about what you want to do if that should happen. Paula McDonald, I need help getting SSDI. I've had cervical spine surgery over 15 years ago. I'm in Georgia. Can you please advise? Well, obviously, Paula, reach out to me. You can see the contact down below. Just go to the bit.ly. Bit.ly is a link shortener. Contact Jonathan 3. And you can reach out to me that way, or go to ssdanswers.com. But use the link. That way we know it's coming from the live stream. So the immediate question I will ask you, if we were to talk about this, would be, you had the cervical spine surgery 15 years ago. Presumably you went back to work, and at some point you must have stopped working, or you're about to stop working. So, question one is, are you still insured for Title II disability benefits? And you need to go to ssa.gov/myaccount to see whether you have enough credits for that. And again, if you've worked pretty consistently up until, let's say, within the last 5 years, you probably do. The second thing, how old are you? Because that will tell me if cervical problems, which is the neck, that means the grid rules very likely come into play. And so if you are 56 or 57, then you have this, light grid, which basically says you can be found disabled even if you can lift, 10 pounds. But if you can't lift 20 pounds and you can't stand on your feet, and realize even with cervical, it may limit your standing and walking, for 6 hours a day. But maybe the lifting is a more important part of it. If you're limited to lifting 5 to 10 pounds only, you've got numbness, weakness in your hands, then you might very well meet the grid. And if you've got pain or pain medications or something else, that would eliminate transferable skills. So a lot of questions I've got for you, but the big question is, are you insured? Do you have enough credits there to pursue disabilities, SSDI? Are you now working? Did you stop working? What kind of work did you do? Again, reach out to me and we'll go over all those questions, and I'll be able to advise you as to what I think your case is about. And of course, the other thing I will tell you is, do you have a doctor, an orthopedist that you're seeing now, or even a family doctor that would say, yes, you've got these limitations? It's not enough for you to come in and say, well, I can't lift 15 pounds, I can't lift 10 pounds. That may be the case, but it really helps to have a doctor that says, I have examined Paula, and based on what she's telling me, and based on the objective evidence, the current MRI, the nerve conduction studies, there's abnormalities there. There are abnormalities there that would prevent lifting or manipulating of the hands, whatever that may be. And that's another thing. This is really important when you have musculoskeletal problems, that there be objective tests, things like MRIs or EMGs, nerve conduction studies, because it's not enough for you to say it. It's got to be shown on some sort of objective test. So again, reach out to me. We can discuss all of those things. Michael Horsley, every time there's a new president, I get reviewed. How normal is this? I don't think there's any correlation. I just think that your case was probably coded to be reviewed every 4 years, every 3 years, whatever it may be. And I've talked about this before, and I still don't have the exact information I need to give you the full breakdown of it. But my understanding is that when a person is approved for disability, their case is coded by Social Security as one where there's likely to be improvement, not likely to be improvement, or uncertain. And of course, if they see earnings, that might also be something that triggers it as well. But it may simply be that your case, and again, we don't know how old you are, if you're in your 30s or 40s, and you've got, ongoing part-time work, and your case was coded as one where medical improvement is possible or likely, you're going to get reviewed more often. Now, are reviews going to increase, under the current new administration? Probably so. I think people that are going through disability are an easy target because there's not, like the AARP is out there for folks who are at the retirement age, big, unified voting block, but people who are going through disability, not so much. So it's an easy target. There's the narrative in Congress that, a majority of people on disability are, exaggerating or downright fraudulent. Easy to jump on that bandwagon and say, people are just, they're all frauds. So I think we're going to see more reviews. Nothing has come out to show that yet, but, I will tell you in the last few years, Social Security has been kind of starved of money. Congress has been, again, under the last administration, has been unwilling to increase the budget to give them the dollars they need to really increase service. The one place where they gave them money under the Biden administration was, to increase the number of continuing reviews. Now, the prior commissioner, Commissioner O'Malley, who's now gone, put a halt on that because he saw the bigger problem was the initial recon and the delays in processing. But he's gone. And I suspect that the new commissioner is not yet been confirmed, but I think is the acting commissioner, or there is an acting commissioner, will be, in that, on that bandwagon to try to increase the number of reviews to be able to go to Congress and say, we kicked off X percentage of people on disability. So I suspect it's going to go up. I wish I didn't have to tell you that, but that's what I think it will be. Michael Robert Jennings says, for step 5 of the 8-step CDR process, type 1 exceptions, it mentions vocational therapy that allows you to do more jobs. Let's see, he's got something else here. What is this? Could it be new vocational license been obtained? I think that what they're talking about would be vocational rehabilitation. Realize that there's a kind of an ongoing tug of war in the Social Security world. On one hand, they want to encourage people to try to work, and that's why you have the trial work period, and you have the ticket to work and all these things, and they encourage vocational rehabilitation. So they want to encourage people to try to work. On the other hand, if they think there's been improvement or you've now got new skills, they want to try to cut you off. But if they're too aggressive in cutting people off who've tried to make improvements in their life, then they're going to discourage people from doing that. So if you knew, for example, that going to vocational rehab was going to result in a CDR and a likelihood of getting cut off, you're just not going to do it. Obviously, you're not going to take a part-time job if that's going to hurt you. So I think, and I don't know, I'll have to look up I'm not familiar with the 8-step CDR process. I know they use the 5-step process for getting disability cases approved. I'm guessing 8-step just adds a couple of things to it regarding, not just medical, but vocational. But I suspect what it talks about is if a person has completed a vocational training program, that would be a factor that would be considered by Social Security, by a judge, to determine that they maybe have picked up some skills that would allow them to return to work. So I think that's because realize that disability is primarily a vocational capacity inquiry. So if you've increased your vocational capacity, then that is very relevant. But I'm not familiar with, you'd call it the 8-step process. I don't know, enough about that to really comment on it. I will definitely take a look at that, and in future live streams we can talk more about that. But again, my thought would be that it's about vocational training that would give you capacity to return to other kind of work. And so you ask, what did this? Like I said, I don't know. Paula, who had contacted or texted or had a question before, says that she's in Georgia. The cervical issue, the pain doctor does not help. And realize, when we talk about a pain doctor not helping, the medical records themselves will tell a story that the pain medicine has either been ineffective or it's been marginally effective or there's side effects. So even if the doctor won't complete a functional capacity form, there may be enough in the records that would help you get over the hump. If the doctor is just anti-disability, and there are some doctors out there who do not believe in disability, then, what I tell people is get another doctor. I mean, I just flat out say it. I realize insurance can be an issue, but if the doctor does not believe that anybody can be disabled, and I've had conversations with doctors who say, well, nobody's truly totally disabled. I'm like, yeah, there are people who are truly totally disabled. So some doctors just don't buy it. And realize, many doctors, if they're treating you, they want to believe that the treatment they're offering is providing benefit, is helping you, is restoring your function. They don't want to put into writing that what they've done does not work, because that may trigger a malpractice claim or that may come back to haunt them. So, you have doctors, you're asking a doctor to basically say what I did not work. That's a tall order. So that may be what the doctors, why that's the case. And again, I would tell you, ask the doctor, why will you not help? If the doctor says, well, I just don't believe in the concept of disability, then you got your answer. Christina reminds everybody to like, share, comment, and subscribe. Thank you, Christina. Appreciate that. Michael Robert comes back. What is vocational therapy? It means so again, I'm going to have to look. I just don't know enough about that part of the CDR process. When I really focus on with CDRs, when I get calls about them, I'm asking my client, have you worked? If so, how much money have you made? Has there been any kind of medical improvement? Have you gone to the doctor? Have you had surgery? What is the underlying nature of your condition? Is it one that might get better over time or with medications, things like that? So I'm really kind of looking at the practical part of it. Social Security has these sequential evaluation processes. In the underlying disability claim, it's a 5-step, and what Michael Robert is telling me, there's an 8-step for CDRs. It's a lot of, like the 5-step sequential for underlying disability is, step 1, are you working? Obviously, if you're working and you're working over SGA, substantial gainful activity level, you are by definition not disabled. Number 2, do you have a severe impairment? Well, severe impairment basically used to be anything. Now it kind of comes to mean you have something that is, documented, that has been, there's some sort of objective or even subjective evidence that it does exist. It's more than just a bare allegation. Step 3 is, do you meet a listing? If you meet a listing, you obviously, you're disabled. If you don't meet a listing, you get a step 4. And step 4 says, can you return to past relevant work? If you can, you're not disabled. If you cannot, then you go to step 5. Can you do any other kind of work? And step 5, the burden of proof moves from you to Social Security. They've got to prove that there's no jobs that exist. At step 4, you have to prove you can't do past relevant work. And then step 5, it goes to the Social Security. Well, if you think about it, what's missing here? There's no discussion of the grid rules. So even though there's a 5-step sequential process, the grid rules are kind of, tacked onto that. Where do they fit in? And again, I think it's sort of part of between step 4 and step 5 is sort of like, do you meet a grid rule? But if you look at the sequential evaluation process, there's no discussion. So I don't really get too caught up in the formality of it, the 5-step sequential. I just really focus on, the theories of disability. There are 3 ways to win a case, and it kind of fits within the 5-step process. 1 is, do you meet a listing? Very hard to do, but sometimes people can, especially if it's not musculoskeletal. If it's an organ issue, you might. Number 2 would be, do you meet a grid rule? Number 3 is, has your functional capacity been so reduced you would not be able to do any kind of work? You have what is called a less than sedentary residual functional capacity. So I sort of take that 5-step process and make it 3 steps, because that's really all that comes up in hearings. My hearing today, I did my brief, and the judge, obviously he's been doing this for a while, and he's like, Mr. Ginsburg, I see you're arguing, grid rules, and you're in an alternative, you're arguing less than sedentary functional capacity. Yep, that's right, exactly right. I'm arguing two different theories. We can argue them in what they call the alternative, which means if you don't think the grid rule fits, then let's consider the functional capacity. You can argue two somewhat conflicting theories of disability at the same time. That is very common in the legal world, where you argue, again, in the alternative. But this judge understood it, and when I do my briefs, I will focus on the either the listing, the grid rules, or functional capacity. I had one last week where, actually, I shouldn't say it. I think it's maybe, is it tomorrow? I don't know. But I've got one where I'm arguing grids. I'm arguing listings. My client meets a listing. Very rare. I'd say 2 or 3% of the time we get to a hearing in my client's listing level. But I had one, either I just had it last week or it's coming up shortly, where I thought it was a listing. Now, whether the judge will accept that, I don't know, but I thought it was listing level. Christina says, please, thank you. I appreciate that, Christina. And yes, that would be much, much appreciated. Zippy, I've been on SSDI for 3 years. I'm 60 in 4 days. Well, early happy birthday. 8th grade education, what's the chance of getting a CDR? Pretty low. Now, they do have random CDRs, so you could get unlucky. And if there, again, is something that would trigger it, like earnings, ongoing earnings, or something significantly that is improved in your medical condition, that might be, grounds for, a CDR. But generally speaking, since you're close to getting retirement disability within 6 years, let's say, of full retirement, Social Security is going to spend their time focusing on people who are 35, 40, 45, because there's more likelihood they're going to get better because they're younger, number one. And number two is that's the real drain on the trust fund. You have 5 or 6 years, you're going to be pulling money out of the trust fund. A 35-year-old may be pulling out for the next 20, 25, 30 years. Big difference. So, where would you put your money, for the biggest bang for the buck? But I think that, at 60 with 8th grade education, I think it's probably pretty unlikely you're going to be reviewed anytime soon. But doesn't mean you won't be. I think it's probably not real likely. All right, Garrett Coleman. I'm 39, L5 root compression, lots of pain, starting the process. Garrett, 39, it makes it more of an uphill battle, I will tell you, because first of all, you've got to prove you cannot do any kind of work at all. Now you have an L5 nerve root compression, which is very serious, as you know. It's causing a lot of pain into your lumbar spine, a lot of pain daily. So what I would tell you is, I don't doubt that you have a level of pain which would prevent you from being reliable at a job. The issue is, at 39, you get in front of the adjudicators are probably just going to turn you down because they're going to say you're too young. You get in front of a judge, there are some judges who almost as a matter of course are going to turn down anybody under 50. You get unlucky, get a bad, judge that feels that way, you got a problem. If you get a judge who's going to say, let me look at this case on its own merits, and having an L5 nerve root compression, and, again, in 2 years, what is that going to look like? You may have a more reasonable judge. The other thing that's going to, come up during the course of your case is what kind of treatment. They will start you with, epidurals or facet injections or radiofrequency ablation or physical therapy or, whatever. And then eventually, if that doesn't work, pain medications they may put you on. That doesn't work, they may say, let's talk about surgery. Well, again, a surgical order is going to send the message to Social Security, this is really serious. That will help your case. But if you don't have a surgical order and you've gone through conservative treatment, real uphill battle. But at 39 or again 40, 41, when this all comes into a judge, what does the record show? Does it demonstrate you've been compliant? Have they tried, multiple types of therapies? Again, the epidurals, the facet blocks, the, radio frequency ablation if it's appropriate, pain medication, physical therapy. Is all that shown that it has not worked, and now the next thing to do is surgery, and maybe you've decided that the risk of surgery is too great, or they look at it and say that, you're not really a surgical candidate because the odds of success with surgery are not that great. So again, there's more to the story to be written, but yes, you are starting from behind because of your age. Unfortunately, that's just it's the way unfortunately it goes. All right, so Paula, you are 56. That helps you a lot. So again, reach out to me. Just contact my office, and we'll go over what your situation is, and I'll give you some guidance as to what you might want to do. But yeah, 56 with cervical surgery, a former, a 15-year ago say this again, cervical surgery. It's not unreasonable to think that scar tissue would have formed. Again, the question I will ask you would be, have you had recent MRIs? When did you recently work? Things like that. But so far, what you've told me, things that I see as real positives here. You're 56, which means the grid rules come into play. You had surgery 15 years ago, so it's not uncommon or unexpected for scar tissue to form. So those things all say to me, this is something worth taking a much longer look at. I think it sounds pretty good. Biol, I hope I'm pronouncing that correct. My migraines are not able to be seen, obviously. How will a medical examiner determine migraines are disabling? They're weekly, being treated by a neuro, and I have an FMLA. Migraine cases are difficult for that very reason. You cannot take an MRI of a migraine or a CT of a migraine. What I have found that works is, the medical records needs to show that the doctor has tried multiple types of therapy. The medications, the prophylactic medications, the immediate relief medications, things like Botox. There's a lot of different medications that are now available for migraines. And so what I would want to see would be sort of a narrative that sort of shows that you've tried one after the other, nothing has really worked, or nothing has worked to remove the duration or frequency. I've had success with people going to headache clinics because the doctors there, have a really good idea of what the therapies are supposed to do. Certainly you're getting a specialist treatment by a neurologist, that helps. But again, maybe to look at if there's possible to go to a headache clinic. But I would say it's going to really come down to, what are the treatments the doctor has done? Have you been compliant? And did the doctor's notes indicate that this has not worked? I had a client, I think she was in Texas, in her 30s. And she had just had she had tried to work a couple of times. And again, that can be something that helps you. Try to go back to work, but you can't because of the headaches, the need to take unscheduled breaks during the day. This woman had gone to a headache clinic, and she literally had tried 7 or 8 or 9 different medications. And her doctors are basically saying, she's compliant, but the headaches continue to come. And, Texas is a hard place. Judges there have typically a little bit lower than average approval rate. We got to win, because I think that the judge realized that this lady was sincere. She was trying to work, but the headaches were just, too severe. And, migraine headaches, for those who have not had them, and I haven't really had one, they are, the type of headache that your head feels like it's about to explode, and you need to go into a dark room, pull the curtains down, and put a, warm or cold compress on your head and not move. I mean, it's just miserable. And of course, and believe it or not, migraines can also occur in other parts of the body, not just the head, but they are just debilitating. The problem is, to some degree, the doctors are going to be looking at listening to what you say, as opposed to looking at objective tests like an MRI or a CT. And maybe down the road, there'll be some sort of objective test for migraine, but it does not exist at this point. So you are reliant on what the doctor said. But I think that in my experience, the treatment record tends to be the deciding factor. Garrett is coming back. I'm getting a lawyer to maybe not get a 9. First time sinking ship. Can't support my family. And Garrett's the 39-year-old with L5 nerve root compression. Yeah, I think that's wise. And again, I would just tell you that in my experience, a younger person needs to have a really consistent medical record that shows you've been totally compliant, you've tried everything, and nothing really has worked. Okay. Carrot 1, is Trump taking away SSI? Getting it for 20 years. I've not heard anything to that effect. I don't believe that there's any discussion at all about eliminating SSI. There have been ideas floated to make the standards for disability, and realize SSI and SSDI use the same definition of disability, which is basically you have to have a documented medical condition, pardon me, that has lasted or is expected to last a year, that prevents you from engaging in substantial gainful activity. But I've not heard anything about SSI being on the chopping block. Obviously, if I do, I will let everybody know, but that is, what I've heard. No, I've not heard anything. Paul, I hope to hear from you. Maybe we'll talk tomorrow. MJ, I guess MJ had a hearing. I think he said he had a hearing in January, or he or she, I don't know if you're he or she. Lawyer didn't say much. I did a good job answering the question. Judge asked vocational experts how long off task and days off they said I can do. 10% 1 day precludes, right? That's very, very common. And is my lawyer saying little, good or bad? It kind of depends. I mean, I will tell you that if I'm winning, I keep my damn mouth shut because I don't want to pull defeat from the jaws of victory. And lawyers are known for talking too much. If I'm winning, I don't need to say anything. God gave me 2 ears, 1 mouth. I use them in that proportion. And that was something I used to tell my kids to their chagrin. If your case is really strong and your lawyer felt like you had a winning argument, you didn't need to say anything, he didn't need to say much, then that could be a very good thing. I've also seen situations where lawyers, regretfully weren't as prepared as they needed to be, and they didn't say anything because they didn't know what to say. I hope that was not the case for you, but many times if a lawyer doesn't say anything, it's usually because he or she feels it's a good case. My hearing today, it went pretty well. I felt like it went really well. I think my client did a pretty good job, and the judge asked one question that elicited testimony that there were unskilled, light jobs, but there was no mention at all of the person being off task, and the client had significant medical issues. Question 2 was he would likely miss, a hypothetical person would likely miss 2 hours a day because of pain and other symptoms, and he would likely miss work 2 or more days of work per month. Vocational witness says, too much. 15% is too much, or 10% in her case. She said that kind of varies between vocational witnesses, but 10% off task is excessive. 2 hours is way more than that. Missed days, no more than 1 day, or 1 day of work, 1 day a month is excessive. 1 day every 2 months would be maybe acceptable. I didn't have anything. What am I going to ask? I mean, am I going to ask a question of, what about if a person was off for 1 hour? There was no reason for me to say anything. The judge he's going to go with it or he's not. And there was really nothing for me to say. I think we were winning. That was my judgment. So I said, you know what? I'll keep my mouth shut and take the win. If I felt like the judge was, really getting narrow and saying 5% off task or something, I might ask a different question, or I might challenge the vocational witnesses, numbers. And that's something that's becoming more of an issue now, in terms of cross-examining vocational witnesses. And we'll get to that in a couple of weeks. I'm going to have an appellate attorney on. We'll kind of dig into the weeds on that a little bit. I'm not going to do it here, but there is a lot of discussion about how to challenge vocational witnesses. But bottom line is that my case today, I felt like we had a win. We had a judge with a fairly high approval rate, much higher than average. MJ, basically your lawyer didn't say anything. Hopefully it's because you were winning, and a win's a win. Take it. Ms. Bell, you were very welcome. You were very welcome. Christina says hello to Garrett, No Sky Garrett, which we have our free case evaluation there. Mrs. Bell. Okay, so she's talking about the consultative mental health evaluation, and she can't remember the 3 words still today. And the 3 words might be, mouse, cupboard, and football. Just things that are completely, maybe mouse and cupboard are related, but you know what I'm saying? It's 3 words that just have no relation to one another. And then 25 minutes later, what were those 3 words I gave you? And again, it's to help determine whether you're processing short-term memory into long-term memory. It's not tricky to try to trick you, but they're trying to ask these questions because your answers will do 2 things. One is it will tell them what your limitations are. And then the second thing is if your answers are inconsistent, it might suggest secondary gain or malingering. So in other words, if you answered, let's say that the one of the questions was the 3 words I gave you 15 minutes ago and you can't remember them, but there was some other test that they gave you that you were able to answer properly, it's inconsistent. Well, both tests are designed to measure long-term memory or medium-term memory. You know, and one of them you answered easily, one of them you didn't. It doesn't make sense. So there are situations where a psychologist will say, you know, the person's, you know, answering on these questions was just internally inconsistent. Therefore, I'm suggesting there may be an element of malingering or what they call secondary gain, you know, changing my answer so that it'll meet the expectations of trying to get on disability, things like that. So when I talk to clients who are about to go for a consultative exam, whether it's physical or mental, it's just do your best. You know, let the chips fall as they may, but don't try to fake it or give answers that are what you think is what's going to help you, because you probably are not going to be correct. Okay, let me go back here. All right. Paula says, you're an attorney in Georgia. Yes, although I work nationally because hearings are done by phone or video, but I've done cases in Georgia for 35 years. And the last 3 or 4 years, you know, or I was a little bit longer than that, but I've gone, because it's, again, hearings are done by phone or video. So my client today was in Texas. Doesn't matter because it was done by telephone. I have one tomorrow in Virginia. Again, it doesn't matter because, you know, it's all done by phone or video. But yes, I am in Georgia. And again, Paula, if you will give me a call, we can talk about your particular situation. Muley, who has been here before, still waiting for that initial decision. Don't understand. I'm expedited in several medical conditions, almost 55, work 38 years. Why will not make a decision? They have every medical record. You know, Muley, there is no answer to that. Expedited maybe because you're 100% VA, or maybe you contacted your senator to have a congressional inquiry that would expedite it. You know, if the adjudicators are backed up, you're going to wait. And right now the delay is, you know, really, really bad at initial and recon. They have not enough people and they've got a lot of claims coming in. So, you know, there's no logic to it other than just overworked. You know, the adjudicators, and if you follow Charles Hall's blog, for example, you know, Social Security, you know, is not the greatest place to work. A lot of pressure on the adjudicators. There's a real big issue about working from home, state agency level and at the federal level. You know, the employees want to work from home. Social Security is trying to get them back in. What I'm understanding from just what I'm reading in the different blogs is that a lot of the, you know, senior people that really know what they're doing are quitting. They're just like, I'm not going to go back in. I'm efficient at home. I just want to work from home. If they're not allowed to do that, they just quit. Or they find a job with a different federal agency and keep all their seniority. So Social Security is really hurting right now. Again, we've got a new commissioner who comes from the world of finance. You know, I suspect he's going to be a number cruncher. So, you know, I'm not expecting this backlog to go down, but Muley, the answer is it's because they're understaffed, overworked, and, you know, don't expect anything fast. There's nothing you can really do about it. Well, thank you, Christina. You know, I don't know if I'm the best out there, but I certainly try to do, I've done this for a long time, and I got a pretty good idea what I'm doing. Okay, so Mrs. Bell is 45. I know you'd asked about, you know, some of the things in your case. And again, 45 is getting closer to 50, but you're still on the no, you know, unable to do any kind of work at all standard, and you're under 50, so it's a little bit more of an uphill battle. Paula, you're very welcome. And again, I hope to hear from you tomorrow. Mr. Donnie Doomsday. Well, that doesn't sound very encouraging, Donnie Doomsday. You are 34, spinal stenosis, nerve displacement, fallen for a few years, was in psych 5150 a few years back. You know, Donnie, if you were 54 or 58, I think you got a really strong case. At 34, you know, it's going to be tough. It's going to be tough because of your age. That's the only reason. I mean, you've got a lot of stuff going on. If all the things you're talking about are well documented and a level of severity is well documented, you know, you might be one of the few 34-year-olds who can get approved because you've got significant problems there. But your age is going to be the big question is how do you get past that? Vince, one of my clients, how are you doing, Vince? He tunes in almost every week. That is very much appreciated. Christina notes that Paula can contact me at this link here, the bit.ly, contact Jonathan 3 for a free case eval. Mrs. Bell says, thank you. Can I hire from SSK so maybe Eric can help? Eric does some Social Security. I do refer some cases to him. I'm not sure if you've already got an attorney or not, but again, reach out to me and we can talk about that. I'm reluctant to take cases from other attorneys. Number one, because I don't want them doing it to me. Number two is, if you've got an attorney who's been working your case, don't want to start changing horses in midstream, as it were. The third reason is that Social Security makes it really difficult, very hard for new attorneys and the existing one to get paid if you switch attorneys. So everything else being equal, unless there's a really good reason, do not switch attorneys, in my opinion. Christina points out that, yes, I'm able to take clients all over the country. That is true. Jen would know because Jen is my senior paralegal. She is in Nebraska. We actually have people literally in multiple countries. I mean, I've got the person who handles our phone and does some medical updating, Paola, is in Mexico City. Jen is in Nebraska. Madeline, who's here a lot of times on the live stream, is in Oklahoma. I have Stephanie, who's in Florida. I've got Iris, who is in Guatemala. We've got a couple other people locally. So yeah, everything has changed in this practice in that it's all done by phone or video, staff included. So, I have an office. My wife and I have an office together. I go in maybe once a week to check the mail. I used to have a person in the office who was there. I don't have a person in the office anymore. I have two offices, a couple offices sitting it. It's really sitting empty. 3 offices sitting. One of them we rented out, just because it's all everything's virtual. There's no paper. It's all paperless. From my perspective, it's great. I'm doing hearings in a t-shirt and shorts because they're telephone hearings. I'm comfortable. My client's comfortable. I've gotten great results. I've got a video one tomorrow. So I'll be, I've got a shirt like this with a tie and a coat, but, shorts on underneath if it wasn't 20 degrees outside. But yeah, it's really allowed us and most attorneys in this area to take cases anywhere, and judges have adapted to that. It used to be I was really concerned about, I didn't know the judge because it was somebody from, Michigan or something. It doesn't matter. Judges they're so used to seeing people from all over the country that doesn't faze them at all. I've actually had a few judges that have seen me on video or the live stream. I've had 2 in the last 5 or 6 months comment that, oh, you're the live stream guy or you're the video guy. So, they sometimes watch it. So, that's always helpful when the judge knows who I am. And I always look up to see what I can find out about the judge. And I'm not saying that gives me any special consideration, but it's just nice to know that the judge knows that know what I'm doing, I'm experienced, so they're not going to try to pull a power play, which sometimes they do with newer attorneys. But yeah, the judges are out there, and then there is a listserv that I belong to, which is kind of like if you know what a listserv is, we're lawyers who do this, talk back and forth, between ourselves. And so let's say I have Judge Smith, coming up in a week, I'll go to the listserv, anybody had Judge Smith, what do you think? And so I'll get some guidance on it. If somebody posts about a judge I know, this is what, because I take notes. Like when I appear before a judge, I'll take notes. The judge was friendly. The judge asked for an opening. The judge was really, trying to trick my client. The judge asked a lot of questions about past work. The judge asked a lot of questions about physical capacity. The judge was condescending, cut my client off, whatever it is. So I take notes. And when I see references to a judge on the listserv, I'll take notes from that, put it into my own database so that I've got, a pretty good idea of what most judges are going to be like, so I can tell my client how to prepare. And of course, we can look to see the approval rate. Muley says it's been over a year expedited. Well, that's not very expeditious. They have every medical record there is, almost 55. You think you meet a blue book or a listing. I can't get right. Just again, they're backlogged. And so what I would tell you, if you've not already done this, is contact your U.S. Senator and ask for a congressional inquiry to find out the status of your case. They will not put their finger on the scale, not going to help you get approved, but what they will do is ask the manager of the office where your case is being processed, what is going on with Muley's case? Why is it taking so long? And magically, your case will get to the front of the line, and you will get some results. So if you haven't already done that, that's what I would do. You do it tomorrow. You just go online. You can do it online. And Christina says hello to Jen. Coup Thunder. Thank you, Coup Thunder. Appreciate. Well, I'm glad to. Thank you very much. I really appreciate you taking the time to say that. And yes, please hit the like button if you do like this. Mark is one of my clients. What are your thoughts regarding participating in an observational study similar to a clinical trial at a reputable hospital with the judges? I think it's fine. I think that anything you can do to show the judge that you are trying to get better is a good thing. You've heard me talk about this before, and that is that you never want to have what is called an attitude of entitlement when you're pursuing disability benefits. You want the judge to know that you are trying to do everything in your power to get better. If that means taking medications with bad side effects, that's what you do. If it means considering surgery, that's what you do. It doesn't mean you have to do it, but you should certainly keep the door open to everything. An observational study where maybe you're given medications or some sort of treatment, I think it says to the judge, this guy wants to get better, and they really appreciate people who want to get better. Trying to work and unsuccessfully trying to work, that is good evidence. Anything you can do to show you are fighting this, and you go into these hearings with the idea of, I do not want to believe I'm disabled. I'm going to fight this, and as soon as I get better, I'm going to be out there working again. I don't want to label myself or define myself as being disabled. And that's the approach you want to take. And so I think that, Mark, participating in a study that may help you, I think is there's no downside to it at all. Manuel Flores Sr. In another channel, it was said that SSA backlog is within millions and claims won't be reviewed by medical professionals as much to expedite them. Have you heard anything like that? I have not. And I don't know if that's the case or not. You may be talking, I know Walter Knott has a very active channel, so he's, he talks about stuff like that, and, he may have a different, if that's what you're talking about, he may have a different read on what's going on. I have not heard that. I know that, Social Security recognizes there is a problem. I know that Commissioner O'Malley was doing things to try to reduce the backlog, and maybe that was part of it. I don't know that we have any guidance from the new commissioner or acting commissioner to that, to the point of, giving adjudicators more authority to not rely on medical experts. So I've not heard that, but I will, you're the second person who's mentioned that. I will see if I can find something out about that, and I will get back to everybody, as soon as I know. But I've not heard that, and certainly we've not heard anything from the new, nominated commissioner, or the acting commissioner to that effect. But, I just don't see how they can fulfill their duties if they're going to, ask a non-medical professional to make medical conclusions. Again, maybe they're giving more authority to read the record, but I don't know that that's gonna really do it. But wouldn't be the first time. I could be wrong. Would not be the first time. All right. So Mark is talking about the observational study. That's great. That's great. Deb is here. Deb is always very insightful. Has really good observations. Has obviously studied this. Maybe you work for, I don't know if, Deb, do you work for Social Security? I don't know. But you've been very, very helpful to answer questions for people. Glad to see you here. Bori Cuba, who was here last week. And isn't it better for them not to value about the CDRs? Isn't it better for SSDI to just not bother with anyone 62 and over, since they're going to take retirement at 62 or 67? Isn't it a waste of time? Yeah, I think that, well, first of all, you wouldn't want to take retirement at 62 if you're on disability. Just ride it out to your full retirement, because SSDI is roughly equal to full retirement. No reason to take it at 62. It just doesn't make any sense. So I would just say stay on disability. But yeah, I think I mentioned that before. If you're really close to full retirement where you're getting your benefits, why would Social Security waste their time with somebody who is that close to retirement? By the time, you appeal it and you get to a hearing, you'll be, pretty close to retirement age. You're also realize at 62, if you've got physical limitations, you're clearly within the grid rules. It's going to be hard for them to win a CDR, number one, because you're older, but more importantly is you're really close to retirement. So I think all those reasons why a person over 60, really over 55, is not likely to get reviewed. Okay, so again, Christina also heard, maybe again from the same place. So let me check on that. I'll see what I can find out. Jen, you're on here. Remind me to check on that. Remind me to check on this question of whether the adjudicators are given more leeway to get rid of the backlog, if there's anything official on that. Trish Wade, who's here usually every Wednesday, says good evening, and good evening to you, Trish. Hope you're doing well. Urgent from Texas. Do I need to concentrate on one ailment? I have chronic stomach pain and injury from UPS. I tell people, if you're alleging disability, you can say 3 things, 4 things. I wouldn't go beyond 4 unless it's really are 4 major problems you've got. But, I think you don't want to dilute it too much, but, many people, I've won a lot of cases where people have a couple of things going on, 2 or 3 things. Back pain, they're diabetic, and they've got, irritable bowel syndrome, or they've got back pain and depression and, something else, diabetes. So I don't think it's a problem to, list 2 or 3 things. You get beyond 4 or 5, it starts to get a little confusing. So I would probably limit it there. But you know what? On the form, on your application, you can list all those things. But what would end up happening is at a hearing, a judge would say, well, I'm looking at the application and this person mentioned right shoulder impingement. There is no evidence of right shoulder impingement, no objective evidence. I'm going to consider that non-severe. Person mentioned gastritis. Well, you've got that. So let's just say the person mentioned gout. Okay, I'll give you an example. I had my client today, has taking allopurinol, which is a medication for gout, but there's no treatment of gout. He's on the medication, so maybe years ago he had an episode of gout. The judge is going to say, well, gout is non-severe because there's no ongoing treatment for it other than the medication, but that's more maintenance, but there have been no reports of flare-ups. I don't think that is something that is going to be disabling inherently, is what the judge might say on that. So yeah, I think if you stick to 3 or less, you're going to be in pretty good shape. 4 maybe, but beyond that, I would be reluctant to go too far beyond that unless there is a really compelling reason to do so. Big One says, hello, everyone. Hello to Big One. This is a person who is here almost every week, which is appreciated. Intubu Okchuku. I hope I'm pronouncing that correctly. Intubu, hello, and how are you doing? Good to see you here. Jeffrey Allen. I was recently medically retired from the federal government with bilateral peripheral neuropathy, almost complete numbness in his feet, almost 100% PNT by the VA, 56 years old. What are your chances? I think pretty good. If you've got peripheral neuropathy in both feet, okay, then, remember we talked about the grid rules before. If you look at the light grid rule, you're 56, grid rule 202.06, you're not going to be walking 6 hours a day. So, you're going to be limited to a light RFC or less. And, if you've got peripheral neuropathy, that is very painful. It can be painful. I think that you could probably eliminate past work with that condition. The PN 100% veterans disability is going to move you to the front of the line. I think based on that, again, I haven't looked at the medical, but based on that, you got a good case. I think it's a strong case based on what you're telling me. Yeah. Zippy is back. Okay, Zippy had, let me go back if I can find Zippy's original. Okay, here we go. I've been on SSDI for 3 years, turning 60 in 4 days. I have an 8th grade education. I'm concerned about his CDR. And now, in addition to that, we are discovering that Meniere's disease, which can be a balance issue, I believe. And then neck surgery. Now I have to have another neck surgery. Yeah, I think that you know, the odds of getting a review are slim, and if you do get reviewed, you're probably not going to be terminated, I think. After winning, Autobot says, after winning your case, how long does it take before you start to receive benefits? Well, you have to get the written decision, which again is going to be anywhere from 3 to 8 weeks. Then assuming there's no holdups, any sort of problem, the money should be there 2 weeks or so after that. And the holdups could be issues with immigration, if there's an SSI component to it, if there's some problem with a prior overpayment, something like that. But generally speaking, a couple weeks after the written decision. Social Security has to do what they call non-medical review. What that means is they are going to look to see, are there any earnings after onset that they need to look at to determine whether or not you in fact went back to work. Tal Schricht, if I'm pronouncing that right, Tal, was forced to retire at 59, still have a workers' comp case going on, just had a quality medical, a QME, I'm guessing that's a IME type of thing last week. Should I file for SSDI? Not going to return to full-time work. The issue you run into is you've got ongoing workers' comp and you're getting workers' comp benefits. Every week or every month you get workers' comp benefits, that offsets dollar for dollar Social Security. So that's one problem. So practically no lawyer is going to touch it because there's no past due benefits because you're not accruing them. That's one issue. Doesn't mean you couldn't apply on your own, but you're going to have a hard time getting a lawyer to take it. Somebody calls me and they got an ongoing workers' comp case. My response is, can't help you until you settle, because they're not going to be past due benefits, and I am not going to work for free. The other issue is, within the workers' comp situation, if you apply for Social Security, that may require you to have what is called a Medicare set-aside in the comp case, and that can make the comp case more complicated. And again, I'm not going to go into exhaustive detail about this, but basically, when you get on Social Security disability, you become eligible for Medicare 2 years after the date of first payment. Well, Medicare does not want to pick up the cost of treating you for something that relates to your on-the-job injury. So they require you in certain situations to set aside, that's what they call Medicare set aside, a portion of your workers' comp settlement to cover medical treatment that relates to your work injury. So Medicare doesn't get stuck with paying for work injury. In many cases, and the problem with the Medicare set aside is that it takes a chunk of your money away, and it may make it really hard to settle because let's say that the settlement value of your case is $150,000, but the Medicare set aside is $50,000. Just making these numbers up, but let's just say that was the case. Well, you may look at $100,000 after attorney's fees, maybe like $70,000. You may look at that and say that's not enough money, and so it doesn't make sense to settle. You just stay on the temporary total disability benefits. If you don't have an SSDI case, then there may not be a need for a Medicare set aside. So that's why I would tell you not to file for Social Security before talking to your comp lawyer, because there could be very good reason to hold off. And I've even had situations where this workers' comp stipulation says that the person agreed not to file for Social Security for 2 years. Now you've got this date last insured issue kind of ticking there, but it just gets very complicated. These two systems, state workers' comp and Social Security disability, do not play well together, and they can be a real pain to deal with. But don't just file a disability case without talking to your comp lawyer. I'll just leave it at that. Mrs. Bell says, I'm amazing. Well, I need to give you my wife's number, so she can tell her that. I don't know if she's really bought into that yet, but I appreciate that. Okay. Well, thank you very much for the very kind words, Mrs. Bell. I really appreciate that. And again, I'll just put this up on there real quick. If you're enjoying the live stream, Mrs. Bell or anybody else, and you want to leave me a nice review, that's where you would do it. bit.ly/Jonathan-review-5. I would really appreciate it. It really does come in handy because people see it, and I think I've got right now 250 Google reviews. Almost all of them are really positive. And that's really, helpful. People see them. I mean, we all look at reviews, and, these are real people. A lot of them are my clients or people I've helped, and it makes a difference. And so it really helps me. Carrie Urigen. This is take 12 months to get a hearing scheduled. Usually not, Carrie. When I'm requesting a hearing, I'm usually getting them in about 5 or 6 months. That's probably the fastest part of the process because there's enough capacity amongst the judges. Now, interestingly, I will tell you that the number of judges has gone way down. A lot of judges have retired; they've not replaced them. But right now, as we speak in January of 25, the big bubble of cases being processed through at initial and recon has not hit the hearing stage. A year from now, 2 years from now, we don't get more judges, we're going to have big delays there. And this is what really concerns me about the budget issues. They don't have enough people to process initial and recon, but they got enough judges. Well, what happens in a year and a half, 2 years, and all those people that have been slowly being pushed through the system, like the snake swallowing the tennis ball, now they're at a hearing stage. And now you got, half as many judges as you need. It's going to slow that down. So right now I got people waiting, 2.5, 3 years. Are we going to be dealing with a 4-year wait to get a hearing? I certainly hope not, but that's a real concern. It really is a concern, but it does. Right now the answer is no, does not take 12 months. KJ said, I had my hearing today. Judge did not have any questions for the VE. It lasted 30, 35 minutes. I knew from your videos it's a good sign. Thanks for all you do. Yeah, usually if the judge has no questions to the VE, that means you've got a really crappy case or you've got a really strong case. And assuming your lawyer felt like you've got a good case and there's good medical there, no questions to the VE usually means the judge feels there's enough to go ahead and award without having to go through the whole VE process. So that's probably a good sign. Robert Long, valuable information, very helpful. Thank you, Robert. You just don't know how long your health is going to hold out, your insight and direction. Okay, well, thank you. You're right. I mean, your health is one of these things where, look, we all know people who are in their 30s and 40s and 50s who, 60s who just are, look like they're healthy, then they get diagnosed with pancreatic cancer. I have a friend of mine that was younger than me. He was in his 50s. I guess it was probably maybe 56, 57. My neighbor down the street, we were in carpool with him. Our kids were carpool together. Worked out, ran, great shape. One day he's having some pain in his side, goes in, pancreatic cancer. He lasted about a year, and then he passed away a couple of years ago. Last guy in the world you'd ever think had this kind of issue, but he did. You see these folks that look like they're in really good health, and next thing you know, they have a heart attack. I have a friend of mine who had a heart attack in the early 30s. So you just don't know. And I'm not saying this to be depressing, but every day you wake up and you're healthy is a good day, and you want to thank the good Lord for that, because it's so easy to take your health for granted. And I would also tell you, again, not that I'm the person who should be giving health advice to people, but I do work out pretty regularly. I try to eat pretty clean. Just pay attention to what you put in your body, and try to eat clean, and try to avoid sodas, for example. Don't smoke. I mean, just stuff that we know is bad for you. I mean, people that I know smoking can be really hard to have it to break, but that is something we all know is just terrible for you. So if you're smoking, please try to stop. Just for your own health, setting aside disability. And I will tell you, some judges, by the way, really hate people who are smoking because they're harming themselves. You're right. You never know, Robert. You never know when your health is going to take a turn, and you want to be as prepared as you possibly can. It's just you just don't know. I talked to a guy yesterday. He's going to be a new client of mine in his 20s, got mugged and shot. He is now a quadriplegic. Here's a mid-20 guy, 20 in his 20s, working a job, living with his girlfriend in an apartment, everything's going along fine. Boom, he gets mugged, shot. He's in a spinal rehab center. He can move a little bit of his hand. Again, crazy story, but stuff like that can happen. So you just never know. You never know. Probably ran on about that a little too much, but anyway, that was just something on my mind because of when I talked to my new client from yesterday. Black Diamonds. He's got a friend named Lance. He keeps being denied for ADHD and Tourette syndrome. We need a lawyer, and he has bipolar. He used to have his check. They cut his check off when he turned 18. I would say this. In my experience, ADHD is really hard to win on because it is overdiagnosed. Obviously, it's something that you see in younger people. They typically treat it with things like Ritalin or whatever, stimulants. I'm not sure what Tourette syndrome. Let me take a look at that so I can comment if I've heard of it. Tourette syndrome is a neurological condition which causes people to have tics. Sounds like I forget the condition, Tourette syndrome, something like that. Or maybe you meant Tourette syndrome. I'm not sure if you're saying Tourette's. Maybe you meant Tourette syndrome. He was getting SSDI, I'm guessing, as a child. The standard for SSI for children is different than the standard for adults. So he got cut off when he became an adult, turned 18. It's going to be really hard at 18 or 19 or 20. It's really, really hard to win. ADHD and Tourette's, I think it's going to be a real uphill battle. You're going to have trouble finding a lawyer. I don't even mean about it, but discouraging about it. It's going to be hard to find a lawyer because you got an 18-year-old with Tourette's and with ADHD who's been denied repeatedly. It's going to be very, very much of an uphill battle. He's going to have to prove that his level of symptomology of ADHD would prevent him from doing anything at all, even a simple entry-level job. The Tourette's, it's going to eliminate certain jobs, maybe interacting with coworkers or supervisor or the public, but it's not going to really a performance issue, I don't think, unless the tics are something that make it where somebody is just, is having some frequency of the tics that they're not able to be functional. They lose, hours of their day or whatever. That's going to be something that a neurologist would have to determine. But, it's got to be really severe. I'll leave it at that. But it's going to be an uphill battle. It's going to be very, very severe. Very severe. All right, Christina, I asked about the fires in Valencia. I think you said you're in Bakersfield last week, I believe. So, yeah, you got to be careful. I would tell you, I'm not a fire expert, Christina, and I'm sure you know this, but get a bug out bag. Put together the stuff that you definitely want to take with you, whether it's mementos, pictures, things like that. Clothes. Get a couple of suitcases ready, and if you have to because they knock on your door and say get out in 5 minutes, you got to be ready to go. So I would say be ready to go. If there's stuff that if you have relatives in other states or other areas that are not close to it, maybe you take some of your valuables there now, just to be ready. But I think that, you got to be, I would be really nervous if there are uncontrolled wildfires, anywhere near me. Again, I'm in Georgia. We have not had that issue before. We've had fires, but nothing like they're in California. You got to be really, really careful. And I hope that you are. Yeah. Jeff, that's a great question. Do you have to be out of work for 12 months? No. As soon as you stop working, if you have a condition that is likely to keep you out of work for 12 months, you can apply right away. So you can have whatever the condition might be. I think you've got something that's pretty severe, numbness, in your extremities, but you do not have to be out of work for 12 months. As soon as you stop working, if there's a reasonable expectation that you're going to be out of work for at least a year, go ahead and apply. If you go back to work, you can always cancel your application, but you don't have to be out for a year. You can, the minute you stop working, the next day file. Okay, so you don't have to be out for a year. How much, okay, Mark, this is another very good question. How much further than the onset date will say, look, they notice you may have filed a claim 6 years ago. And what we're getting at here, what we're talking about is reopening old claims. In general, if you file for disability and you're denied and you reapply within 1 year of that denial, you can reopen. You have the right to ask the claim to be reopened for any reason at all. They don't have to do it, but if there was, for example, you were denied and there was evidence that was not part of the folder or the file in that prior application, but now it existed, but it wasn't recovered by Social Security for whatever reason, that would be a reason to do it. Judges, I'd say 50-50. Sometimes they will reopen a prior application. Sometimes they just will not do it. I had one judge one time say to me, as a matter of principle, I never reopen old applications. Why? Because she didn't want to. But, it's got to be within a year of the initial denial from application number 1. There is a rule that says that if you were denied more than 4 years ago, you can ask for reopening as long as the reason why you didn't reapply within that 4 years was because either Social Security misled you or you didn't know you had a mental health issue or an educational problem or something that prevented you from doing it. Very hard to prove. I think that's a very, very uphill battle to do. And beyond that, it's almost impossible unless you can prove that Social Security deliberately misled you. And even then, it's going to be really hard. So I think if you had a 6-year claim 6 years ago, it's not going to be reopened as a practical matter, especially if you went back to work and you worked after that because you may have been claimed for disability 6 years ago, and then you went back to work for 2, 3, or 4 years. You were not disabled for that time. Therefore, you can't say you had an ongoing disability for the last 6 years. Plus, 6 years ago, you were 6 years younger. Now you were older, and I don't remember how old you are, but you were older. You're older now. You're more likely to win now. But I think realistically, Mark, you're not going to reopen. Not going to reopen a 6-year-old claim, unfortunately. Angie, 48 years old with major depression, PTSD, and some spondylosis on the MRI. Spondylosis is degenerative disc disease or arthritis that we all have. So it's not a unique condition. I mean, it doesn't mean it's not serious. It's just not, it's a fancy word for degenerative disc disease. How hard is it going to be at the recon level? Difficult, very difficult because you're 48. Depression, PTSD, and back pain are the two most common things they see, so they make it really hard to win those. You're going to need and because the grids aren't going to apply, you're going to need, because you're 48, you're going to need a really, really supportive doctor that says that your level of impairment because of the mental health and or the physical is such that you would be unable to do anything at all. Again, I've seen a lot of cases where people go in with mild to moderate depression, mild to moderate spondylosis. It does not move the meter unless you get a judge with a really unusually high approval rate. So, at recon in particular, it's just almost, I'd be shocked beyond belief if they approved you. At a hearing, it's going to be really, really hard too, unless you have really, really strong medical evidence. I hate to be the bearer of bad news, but that's just what my experience has been, at least. All right, Deb. Right, so Deb is making the point that the person named Tal, I don't want to destroy Tal's last name, Tourette, but yeah, you want to find out what your date last insured is. That's the last date you had insurance credits based on your earnings records that qualify you for SSDI. Once your date last insured is in the past, then you have to prove you became disabled. Your onset is before your insurance credits ran out. My hearing today, my client's date last insured was December 31, 2024. Okay, not a big problem. Medical evidence goes way back before then. My case 2 weeks ago, date last insured December of 2020, the medical evidence supported disability as of 2022, denied, and the decision said, there was no evidence to show this person was disabled before his date last insured. Now you could pursue SSI, but that's got its own issues. And in his case, he couldn't because his wife was working. That would have offset the SSI. Do the grid rules apply? Kim Moak says, do the grid rules apply to an applicant with a master's degree? Yes. If you look at the grid rules, and let's take another look at them here. Go over here. All right, so if you look at the grid rules, you will see when they talk about education, it is basically, limited or less. It can be three things. It can be unable to speak English is one of them, or illiterate. Then it can be limited or less, which is less than a high school degree, or high school grad or more. So there's no difference between a person who is a high school graduate and a person with a master's degree as far as the grid rules. Where it becomes an issue is the transferability of skills. A person with a master's degree, by virtue of going to school, is presumed to have intelligence and skills that would more likely transfer. So you're going to have to show that your skills don't transfer because of significant other issues, non-exertional problems like medication side effects, severe depression. It could be pain, things like that would make a transferability of skills very, very unlikely. So that's the issue with the master's degree. It's not the fact that you've got a master's degree. It's just that, it will be presumed that you have more capacity to transfer your skills. Now, if you don't have any skills from past work, meaning that and I'll give you an example. Let's say that you did skilled work and you stopped skilled work 7 years ago, and then you got a job doing, something, packing ink pens in a box, or just something unskilled or very low and semi-skilled. Well, they only look at the last 5 years. So if your skilled work was done more than 5 years ago, you don't have any transferable skills by definition. And I've never seen a judge say, well, because you've got a master's degree, you should be able to adapt really easily. They really look at the work skills more so than the master's degree. So I've had clients with PhDs, MDs, I've had dentists, I've had lawyers, I've had engineers, meet the grid rules. It just is not as big of a deal as you think. It's something to be aware of, but it's just not as big of a deal as you think. Manuel says, how long does a vet's 100%, so if you're 100% permanent total by the VA, they will expedite your claim. So if the average claim is taking 2 to 2.5 years, if you're 100% vet, I've seen them go to hearing within a year. So I would say, start to finish before you get to a hearing, it's going to be closer to a year. That has been my experience. Now, whether that's going to change, I don't know. But right now, you're going to get to a hearing a year faster than everybody else. All right. So I think that's, okay. So Deb answered the question. No. Does the grid rules apply? They do apply. I'm sorry, Deb, I disagree with you. They do apply. You have, if you see here, high school grad or more. So if you can have the grid rules can apply to people with a PhD. It doesn't matter because all it asks for is high school or more. And the real question is whether the, whether the skill, whether the intelligence you've got would be a factor in terms of transferability of skills. But yes, having a high school degree or having a college degree or a master's degree, they still apply. Ms. Chocolate 4040, what if you have epilepsy? I have an epilepsy case tomorrow, a 35-year-old gentleman with epilepsy is not controlled. I think it's a winning case. I rarely take cases for people that young, but in his case, he's had multiple, he has 2 or 3 a week of the grand mal seizures. They tried him on every medication. The only thing that slows him down is a medication that puts him to sleep. We'll see how it goes, but if it's got to be, basically it's got to be seizures uncontrolled by medication. And we'll see how this one goes. But yeah, you can win. Now, I know some lawyers who feel that epilepsy cases are almost impossible to win. I don't believe that, but realize that seizures, one thing I have noticed, people call seizures, they use that term for a lot of things. The seizures that Social Security is looking at would be the grand mal, where, somebody is on the floor, convulsing, the eyes rolling back in their heads, and then they, it takes them, 2 or 3 hours to recover from it because it's so draining. There's also the small seizures, the petit mal seizures, where you sort of lose track of time and you're kind of staring straight ahead, and you're not convulsing. Social Security tends to see those as less significant. Not sure why, but they do. So I think the seizures that we're talking about need to be the really significant ones where you're just out of control. You can't control your body. If you've got that type of seizure, I think that your epilepsy case is more viable than if you have the other kind. Jeffrey Allen, who we talked to before, 56, have enough work credits. Again, assuming no workers' comp, yeah, I think you've got a winning argument from what you're telling me. Absolutely. Christina says, do not forget to smash, not just press it, but smash it. Smash that like button. Smash away. Please. Yes, thank you. Ruthless. My husband is a 47-year-old veteran. Maybe there's another part of this, Ruth, but I'm not seeing anything else there. So 47-year-old veteran is not disabling, but I'm sure there's something else there. QQQ says Nicarnivoro, maybe not carnivore, okay. Is it true that DDS work are the ability to make this? Okay, somebody's asked this before, and I have not heard that, but I will certainly look into that. When do you think, Geraldo Rangel says, when do you think that SSI will start sending the increased benefits of Social Security Fairness Act that was signed by Biden? I mean, as far as I know, that is in process. I think that eliminated some offsets and things like that. But I've not seen any rulemaking on it yet. But to my knowledge, that's not subject to being overturned. I think that was passed. I'm pretty sure that was it's in force. But I've not seen the actual timing on it yet. Okay, socially disability. Okay, that's those guys says, please, if you want a case evaluation, now let me put that back on here. Because he gets mad at me when I don't do it. There we go. Okay, case evaluation. Okay. Okay, so I think other people have seen this, and again, maybe that was Walter's channel. I don't know. I'm not sure who else is doing these, but that may be when that's from. Yeah, I think that's right. I think that the issue in a disability case is not the diagnosis, but how the diagnosis prevents you from being a reliable employee. Jarius. Okay, the appeal. Okay, so basically, when you appeal an onset date, basically you're saying we disagree with the finding of the judge, and we're appealing that. And basically, when you appeal that, basically what you do is you ask Social Security to reevaluate the decision, and you're appealing it almost as if you lost. The risk is that you're putting your whole case back into play. And theoretically, the appeals council could say you're not disabled at all. On the other hand, that's pretty unlikely to happen. It could happen. I've not really ever seen it happen, but it could happen. But if you're alleging the onset date, and I think in your case, I don't want to talk about specific cases, but in a case where somebody had lots and lots of past due benefits cut out, it would be grounds to do that. Jarius, I will make sure that one of us gets back to you about that tomorrow. I'm not going to discuss your case, on a live stream for obvious reasons. Okay, so a lot of people have heard this, and I'm guessing it was Walter's podcast or live stream, but I don't know. All right, Ms. Crystal has an MRI scheduled for tomorrow, but I already had my hearing. Will the judge request the results? Maybe. Sometimes they leave the record open, sometimes they don't. So we'll just have to see. Tall, do I take cases? I do frequently. It's a lot of cases out there because a lot of people live in California. And again, it's all done by photo or telephone or video. Okay, Victor's having, not sure what song means, what that means, but I'm 41, going to be 42, of a car accident 4 years ago, lumbar spine. Again, I would say this, Victor, you are younger. Obviously 41, 42 is younger. You had lumbar and cervical surgery, which obviously is pretty serious. If you've not had really good results from that, again, you may be in that narrow group of people who can still pursue disability even in the early 40s because of really bad, damage to your back and surgery that did not help you. So yes, it is possible. Again, more of an uphill battle because of your age. If you're 57, much stronger case, just because that's just the way Social Security looks at it. But it just really depends on how bad the MRIs look and how bad the functioning is after the accident and the surgeries. Okay, in Tubu, I have pulmonary fibrosis. Lungs are scarred from being in a coma, from COVID, coming date. So you've got kind of long COVID type of thing. And I think that, my experience has been that with long COVID, they look at breathing issues as the main complication for long COVID. I think that you're going to have to look at some pulmonary function tests to see how bad the breathing is. And really, I would ask you this, what is the practical effect of it? Do you get out of breath really, really quickly? Do you have times when you just pass out? Are you really fatigued? How would this prevent you from working? And realize that damage to the lungs, there's a listing for pulmonary function. So if your pulmonary function, there's something called the FEV1 test, and there's different types of testing on spirometer. So if you're at listing level or close to it, that would really help your case. But if not, the practical question is, what does this mean in terms of your functioning? Because realize Social Security defines disability in terms of how your medical issues prevent you from reliably functioning at a job. But I wish you the best at your hearing. But that's the main questions I would have. But yes, there is certainly a chance to win. Okay, so Lily's asking about this new regulation or procedure that we've been hearing a lot about that gives adjudicators more authority. And again, I've not heard that, but I will definitely look into it. Everybody seems to be talking about it. Yes, migraines are no joke. Absolutely. Okay. Ruthless is back. He's 47 years old, 100% P&T with SMCL, due to severe PTSD. I'm guessing that means he needs help. Medically retired from federal job. What are his chances? I think that, mental health is one of the areas where the age is not quite as big of a deal. It really comes down to what the reports say. If he really is not able to function independently, and it's well documented, and he needs, and again, I'm not sure what SMCL is, but you said aid and attendance, so I'm guessing it means that he needs, ongoing support from somebody else. That would be work preclusive if you have to have another person there to assist you with activities of daily living. That would be work preclusive. So if the medical record documents that, then he would have a very strong case. Okay. Okay, so Rich Gardens. Thank you, Rich. We have an emergency message. Let's see if we can find that real quick. EM 2509, Social Security. Okay, so it looks like it was Walter. It looks like talked about this. Let's see here. Let's do a quick search on EM 2509 and temporary instructions about disability. Okay. You know what I'm going to do? I'm not going to sit there and read this whole thing. If you want to read it yourself, and I'll read it for next time, I'm going to put this in the comments here. And so if you want to look at it, you can take a look and see what you think, and I'll see what I can find out about this, and we'll report on this next week. Okay. All right, so we've got another 5 or 6 minutes here. All right, Chantet. Hello, Mr. Ginsburg. Ginsburg's fine, but it's Ginsburg. Ginsberg. 49 years old. Has been in recon for over 5 months. What's it normally take for recon? Thank you so much. I'd say 7 to 9 months. 5 months is, on the early side, but I'd say, you'll probably hear something, in May, would be my guess. Mercy Padilla. Hello, Mercy. How are you doing? Jeff Herman. Jeff is an attorney friend of mine. He's been on, a guest, and we'll get him on soon. We talked about not wanting to snatch defeat from the jaws of victory. We both know if you're winning, keep your mouth shut. That's exactly right. Anything new in VE examination? Yeah, and what he's talking about is that there was some rules that came down that basically tell Social Security not to rely as much on the Dictionary of Occupational Titles because it's so outdated, and that when they give numbers, they have to state, the vocational witnesses have to state where their numbers come from. And so what judges are doing is at the end of every hearing, when they ask the VE questions, they call it like the ruling XYZ questions, and they ask, where did you get your numbers from? And there is actually a lot of chatter on this on the listserv because I'll just leave it like this because it gets really granular, and I don't want to get everybody confused. I don't have much time left, but there's really no great source of numbers, accurate source of numbers that tells us how many jobs exist. And within these codes, you may have a lot of different jobs, and the DOT, descriptions of jobs, and it's called the SOOC, I think. It's just, they're like different languages. And so the VEs are having to kind of extrapolate how many jobs exist. And so if they come up with a job in the Dictionary of Occupational Titles, they try to say, well, this job may be in 5 or 6 SOC codes. Well, the problem is we know how many jobs in the SOC codes, but we don't know how many jobs this particular job would be. So it's really hard. And there are some of my colleagues out there who are basically saying every bit of VE testimony is inherently flawed because there's no good resource to know how many jobs exist. I don't think that argument's going to ultimately be successful, but it may force Social Security to change how they do that, how they deal with this issue, because realize that, they have to prove at step 5 of the sequential process that jobs exist in significant numbers. If there are 10 jobs, being a typewriter repairman, you have the capacity to do that. That's not a real job because there's only 10 of them. Okay, so you've got to have enough of them. So the numbers of jobs, we don't really talk about that much, in this live stream, but it's got to be a significant number of jobs. So the inherent problem is we don't know how many jobs there are for any given DOT code. And since the DOT has been kind of phased out, well, we don't have a replacement yet. They're having to kind of extrapolate and kind of guesstimate, and it's really not very accurate. Now, I think Social Security is going to assume that there are certain jobs, out there, being a file clerk, let's say, or being a, small parts assembler, that there are a sufficient number of those jobs to constitute a, reasonable number of jobs that people could do. But some of the more unique jobs, there may not be as many. So, but the answer to jump onto Jeff's question is yes, there's definitely a change in what they do. I suspect that there are going to be folks out there, a couple of lawyers, and Jeff and I knew who they are, who are going to take this to, district court and circuit court, maybe even the Supreme Court, and we may get a completely new framework for evaluating jobs. My money would be on it's not going to get overturned the way a lot of people think that there's not going to be any vocational testimony that has value. I just don't think they're going to do that. But there may be some additional changes because obviously we got the DOT reduced in importance because people were protesting against that. Okay, couple more minutes. Recon November of 24. So Mercy, you're probably not going to get a decision until July, August of 2025. Okay, so BL says for the migraines, the MRA does show something. Yeah, absolutely. If you have an MRI report and you've got an article, submit both of them because there may be some evidence that the judge is not aware of. If you've got a scholarly journal, a respected medical journal that says that this MRA result, a circle of Willis, which is a part of the brain structure, that there's an associated with migraines and you got proof that you meet that, absolutely get that in there. Okay, a couple more questions. A case was filed for recon. The adjudicator has requested functional reports. That's good that your case is being worked. So that says it's being worked. The chances are it's going to get approved on the sooner side, but I still think, 6, 8, 10 months is pretty much the likelihood. All right, we're going to have time for a couple more questions. 50 years old, worked 35 years with multiple comorbidities. Yeah, I think that definitely helps because comorbidities means there's other medical problems that complicate the main one, maybe a good way to put it. And so, yeah, that's going to, those things alone may not be disabling, but, let's say that you've got obesity. I'll just take one as a comorbidity. I don't know that you do, but let's say that you did. Well, that may eliminate jobs requiring climbing on unprotected heights or ladders or doing a lot of walking. Let's say that you've got your allergies to pulmonary irritants. That may eliminate jobs that put you in, where there's a lot of dust, fumes, and gases. So you can start chipping away at the number of jobs with those comorbidities, even though any one of them may not be enough to totally disable you. Okay, so let me go and tell, I want to get this one. Do not close your comp case. Just talk to your comp lawyer. I think that's the best thing to do. Talk to your comp lawyer there. Okay, we've got a couple more, and I'll keep another for a few minutes, but we're gonna go in just a few minutes because it's getting late for me, and I got a hearing tomorrow morning. All right, Hawks Fanboy 11. How does age and gender factor in SSI? Age is a factor because it's always a factor. Older, once you get over 50, it's easier. Gender, to my knowledge, is not a factor at all. I've never seen gender be a factor at all. Oh, fibromyalgia. Okay, so you said you got fibro. I mean, my experience has been that, Social Security, I've never won a male fibromyalgia case. That's not because there's a rule that says men can't have fibromyalgia. It's just that when judges see a condition like fibromyalgia, it's almost always at a disabling level amongst women who are in their late 40s, early 50s. So it's really rare to see a 29-year-old male with fibro. And so since it's so unusual, they don't typically approve them. I mean, the 29 is going to be a problem, and fibro is going to be a problem. I mean, you got a real uphill battle, unfortunately. But there's nothing in the law that says that a male can't have fibromyalgia. It's just that I've never seen one of them approved. That's the issue. Okay, so it was Walter. Okay, that's fine. Walter. Okay, thank you, Hawks fam. I appreciate the. Thank you for the $5. I really appreciate that. And again, I don't mean to discourage you. If you have a severe case, I would just say that your documentation needs to be at a really, really high level. Okay. Let's ask one more. Let's get one more here in there. Let's see here. Okay. Okay, how am I going forward? I'm going to stop soon. I need to stop soon. Okay, so let's just take this one here. Esoteric Fitness. I think you were here last week. Had suffered a TBI during a work accident. And my question is, these docs, workers' comp docs, will they have to write summaries for SSI? I've had your own. Workers' comp doctors are always going to be a concern for me because they're being paid by insurance companies. So, the records may be perfectly viable, and you're going to have to submit them, but I would look at them to see is there anything in there that suggests a minimizing of your symptoms. That could be a problem there. So I'm not a big fan of workers' comp doctors in Social Security cases. If you've got your own, that would certainly be better. You've got your own psychologist or psychiatrist for, I definitely think you want to have your own. That would be good. That would be very helpful. Okay. All right. Very good. So I guess I'm not sure if Jody's my wife. Jody was your attorney, but I will let her know that she's got a fan, which is always a good thing. All right, we're going to end it on this. Christina says, do not forget to like the video. Please do. Thank you very much. And again, if you find this helpful, please leave me a nice review. I will check into this emergency message that I posted there, see what I can find out about that and what that means as a practical matter and whether it will help us or help the Social Security disability community get expedited decisions, because that's really, really important. And thanks to Walter Knott for mentioning that, because obviously a lot of people watch him and me, and nice guy. One of these days we'll have to collaborate, but I'm glad he mentioned that, and I'll see what I can find out. So anyway, for now, I will be taking my leave. Everybody try to stay warm out there. I know it's really, really cold, and be well, and I'll see you next Wednesday. Thanks a lot.